Hello and welcome to Hey Not the Face with your host John Nash and your producer me, Steffi Haynes. And today we have a guest. That's right, you heard us right. We brought a guest for you guys today. We have one of the antitrust attorneys, the guy that initiated the whole thing, Rob Maysey. Rob, welcome to the show.
Hey, thanks for having me.
Absolutely, John. I am going to turn everything over to your capable hands. I will only interject if I think I don't understand something, so take it away.
Terrible decision you just made. This show is going to be a disaster. We don't normally do interviews, but we thought we'd get Macy on her mainly because I'd noticed you have this major decision, and I haven't seen you guys making the rounds in the press. The plaintiffs or the attorneys, I've seen you do some interviews, so obviously you're available, and I don't want to belittle the people who did it. They did a great job, but doesn't seem to be the major sites are asking for interviews with you guys, or at least you're not giving the major sites interviews. I don't know what the answer is to that. So I did think it would be great, since you are out there making the rounds, that this seems important, that we should probably talk to you. So I guess the question,
I agree.
I guess the question is, are people asking you to do interviews, and why are you guys not making the rounds?
For the most part, no, we just do not get asked. We never have been asked, since basically our inception, we just don't get asked.
Is it because you're terrible speakers? Is it your lack of charisma? Or is there something else you're suggesting there?
I mean, my best guess is we were so early on. There's something wrong with the UFC that people were not ready to accept that message when we were initially saying it, back in 2007, 8, 9. I think there was some animosity towards us because at that time, UFC was kind of the darling of everyone's eye. And that sort of, it appears to have just carried over. A lot of these sites don't cover us. They never have. I don't believe it's anything that we're doing or not doing. It's just is.
Well, I should point out that you were on MMA Uncensored, I believe, in the Bruno Gallen show, and both of them are really interesting interviews. People want to check it out. And John Fitch, got to give Jimmy Smith credit. He actually has been covering this suit, and he had John Fitch on an excellent interview. So I should give the credit to those guys for doing it. And I also point out I am going to I sent a request to the UFC and their attorneys that they want to come on the show to talk. We'll see if they'll accept. But anyways.
Sure. Yeah. You'll see. I believe Bloomberg is going to do another story with some of the fighters, probably some of the attorneys on this, maybe the Wall Street Journal. It might be to the point where it's going to start to jump into more mainstream media outlets. There was a time early on when there was definitely a reticence from our team's viewpoint on giving interviews in the first place. And then if they gave interviews, they wanted to basically give little rote canned responses that you were, kind of cliche, boring, not very informative. I think that's changed a little bit because they realize, this, unlike most of these cases, this case has a sort of a public notoriety component to it, in that the athletes are famous, they've been in the press their entire career. And it's sort of unlikely to ask these guys that have been going through this for 10 years now not to talk at all. That's tough.
Mm. And we'll get to the details later of the case and stuff, but there's also the component as a class. You have to inform the class. And if you're not talking, is that one of the reasons you guys weren't really allowed to talk, because you hadn't officially made a class yet? So you might be interfering with the membership. Is that fair to say?
Indirectly, it was more a fear of, as a class rep, we have to be very careful as to what we say, because they're not speaking for themselves individually. They're speaking on behalf of the entire class. So you want to avoid things that are very individual to you and say things that are applicable to all. And there's a learning curve to that. I think that was the reason initially there was a reticence to speak. And I do believe that is at least ameliorated slightly now that we do have the class certification order and they have been named class reps. because like you said, there is now an educational component as to why it's important for us to speak. We have to get the message out to fighters. You guys are represented. The same attorneys that have been working on this case for 10 years are now your attorneys. You don't have to do anything. So if you get solicitations in the mail saying, in order to share in your fair share of the recovery, you need to retain your own counsel, that is not true now. The impact of the judge's order from August 9th was, instead of 6 fighters asking to file suit on behalf of 1,214, it's now those 6 are representing 1,214. So our case just became much, much bigger with that ruling.
Okay. Well, first of all, it must be a relief to get the class cert and the hearing and have dates and stuff set down, because what you've gone through. I guess I'm in the intro of the show, I give a description of what's involved in the suit. I give the basic details. We don't have to go to that. But what's been the journey to get here for you and your team to get this far?
From class cert or from filing, or how far
we can go back from. Let's start with the moment when Carlos Newton showed up and you guys filed on December 14th, and you can even go before. Me and Brent Brookhouse were driving you guys nuts, asking questions, even though there's a lot of other strange stuff going on with other parties at the time. We can go
so I think this is interesting. So I'll start with this, I guess. So in 2012, I get a call from a fighter that goes into my voicemail, and it just sits there for a few days, because I was at that time kind of tired of doing favors, and I just put it on the back burner. I was like, no, I'm not going to call that back. So he calls again, same guy, leaves a voice message. A couple days pass, and I'm like, I can hear the number, but I still don't know who is calling. I don't know if it's a writer or a manager or a fighter. I have no idea. So I finally write down the number and I call. I go into voicemail. He calls back, and I get him on the phone, and he's like, here was his lead. He doesn't say hello. He didn't say anything really. He says, yeah, so if I fly into Arizona, do you think we can meet up? And I say, yeah, sure. Thinking he wants to go to dinner or something. Who am I talking to? And for anyone who knows Carlos, he mumbles a little bit. So he says, Carlos Newton. I'm like, who? Carlos Newton. Finally, I figure out who I'm talking to, and it was kind of surreal to me, because I literally had Carlos and Matt Hughes's poster hanging to my left, signed on the wall of my office. So I was kind of chuckling. Hey, where'd you get my number? And he said, Pat Militich. Like, okay, yeah, I guess I should be talking to him. I'm like, yeah, sure. You come in, I'll meet with you. And again, I'm thinking, never going to come in. Sure, I'll meet with him if he shows up. He shows up like 2 weeks later. Lets me know when he's coming in. I'm thinking we're going to go out to dinner. He's coming into Arizona to go on vacation or something. No, he wants me to pick him up at 8:30 in the morning, drive him into my law office, put him in a conference room with my Westlaw password so he can pull cases all day. He did that all week. So I think it was like Wednesday or Thursday of that week. I take him out to dinner and then take him to a baseball game, Diamondbacks game. I'm like, Carlos, what are we doing, man? He starts laughing. He goes, Macy, I know you figured it out. I've seen your articles. I've seen your presentations. You're filing an antitrust suit. And I start laughing. I go, Carlos, man, I'm a real estate attorney. He's like, I don't care. You're filing it. So the next day we started. And where Nash comes into this is Nash and Brent Brookhouse started calling me probably a good year and a half in advance of us filing that suit. And Nash would say stuff like, come on, man, I know you're working on an antitrust suit. And I would laugh. I'm just a real estate attorney, Nash. I don't know what you're talking about. Read my background. I don't do any antitrust. This goes on for months. I'm just kind of jacking around with Nash because I want to delay the press is really what I'm doing. He calls me, I want to say it was like February or March of 2014. And he says, Macy, you were in San Jose and you met with X, Y, and Z. And he named like 4 of the 5 people that were at that meeting. And I'm like, oh shit. What am I going to do now? Nash goes, you either give me something or I'm publishing tomorrow. So I said, yes, Nash, I'm working on an antitrust suit. Sit tight. I don't want you publishing yet, but you will be first to publish. I promise you that. And that happened right around 9 months later. It took the whole process from Carlos meeting to filing ended up being right around 21 months. I started writing 15-page memos, sending them around to firms. I got nothing. 25-page memos, really nothing. So in 2013, around June, I decide I'm going to write I'm going to take like 6 months and I'm going to write a long brief with a lot of exhibits. And it ended up being, I think, 117 pages long with about 300 exhibits that I put in binders, and I FedExed them to these major national class action firms that I needed to come do this with me. Within about a week of those FedExes going out, we had meetings with really the two best in the country. They signed on soon after that. We started working on basically the revised complaint in 2014, which we ended up filing towards the end of that year. Now, class cert, we ended up filing, I believe, our initial motion for class certification, I want to say around 2016. And then we had a series of hearings throughout 2018 where the judge is holding evidentiary hearings with the major witnesses that he's ultimately going to use in his class certification decision. I believe we had a status conference, I want to say September of 2019. And at that status conference, the judge says, my class certification decision is going to be issued soon. I hoped to have it here with me today, but I'm not quite finished. We had another status conference, I want to say like around March of 2020. And at that status conference, he literally said, expect it next week, I believe.
Said expected Monday, I believe.
Yeah,
like a week from for Monday.
Yeah,
and then
right.
And then 3 years later, we finally got it. But yes, that should be that's the question. What did you ever start getting nervous that he was never going to grant class certification? Because we ran into, for people that are not familiar with the case, we ran into, one was COVID slowed things down. Two, there was this other case that that had a similar argument being made, and he needed to let that pass through the Ninth Circuit Appeals Court. But really, that also just seemed to be dragging on forever. So were you getting nervous at that point that after he had said it verbally several times and even said he had it written and it was going to come out, that we would not seen a written class certification? The class hadn't been certified in writing until earlier this month.
I personally was not nervous on the merits. I was getting nervous about the delay just because it was starting to wear on our plaintiffs. I mean, in all honesty, they're sitting around waiting 3 years when, basically we were told it was coming out within days. We ran into the pandemic, which caused a delay, sort of just our luck. There was that Olean decision, or Olean, and also in the Ninth Circuit that went up on a full panel appeal, which caused quite a delay. And then our judge basically took that appellate decision and cites it throughout his class certification order in our case. That might end up being fortuitous to us in that he is using the latest authority from the Ninth Circuit in writing his opinion, and he cites it repeatedly. So hopefully, that weighs in our favor on the pending appeal.
Well, we're going to get to the appeal in a second because I want to go over some of the stuff, the questions they raise about your case, and some of my own personal problems with your case. But we're going to go back for a second. I don't think people quite realize this. As much as this case is dragged on, we live kind of in a post Lee versus Zuffa world, because before Lee versus Zuffa, other people would write estimates what the UFC finances were. And, sometimes it was kind of close, sometimes it wasn't, but they were estimates. There was nothing concrete. We now live in a world, or we hear stories about how Joe Silva would deal with the fighters. But now we live in a world after your discovery where we know concretely what they were paying from the first year of Zuffa, 2001 to 2017 at least. And we also have details of their negotiating tactics and their pay tier structure and stuff. So I guess, dude, are you surprised at maybe how little attention or how little credit you guys get for that material being out? Because it almost seems to be taken for granted now that the UFC, everybody will say, Jorge Massa, the UFC only pays 18% to revenue. It's like, well, where did that number come from? No one seems to credit that.
Yeah. So, I mean, to your point, back in 2008, 2009, 2010, 2011, I was making public comments where I'm doing exactly what you said. I'm estimating. And it wasn't, shot in the dark, very random guesses. It was, I'm talking to managers at that point, and I'm seeing contracts. I believe right after the ESPN story with Lorenzo Fertitta, I got brought in behind the scenes to the LOIs. Before then, I had missed that component. And by LOAs, I'm sorry, letter of agreement. It's basically a side letter with an extra bonus for a fighter to fight in big fights. Sort of the major fighters get those. So my estimate was, getting closer and closer and closer over a period of time. But at that time, especially, pre-Strikeforce, let's say, the fact that I was making estimates at all, that was attacked, virtually uniformly. I was called a fraud. People would say I'm making up these numbers. They have no basis in reality. I have no sources. I mean, repeatedly. All of that was not true. In fact, my estimates that I came up with in doing a damage model in this case, just, sort of to entice these firms to come in, ended up being very, very close to Hal's, Dr. Singer's. And I was just using sort of a rudimentary Excel with control cells and a boxing yardstick. And then I was gathering basically pay information as best I could from public sources, and I was supplementing it with sort of what I knew to be these LOAs. I ended up being very, very close to accurate, just using that methodology. I forgot what you asked.
No, just about the lack of attention to that, or credit for getting those numbers out there. But I'll add another one too, is the contract changes that the UFC made in 2017 that basically let Francis Ngannou get out of his contract because there was a 5-year max. That was, in fact, they basically, I think Bill Isaacson, their attorney, basically admitted that they were introduced because it mitigates the damages in the case. It basically changes the landscape you have two, and we should explain too, you have two cases going on right now. There's the Lee versus Zuffa, which has been certified as a class action. And then there's a second, and that covers from 2010 to 2017. But from 2017 on, there's a separate case that is now going to progress, but it has not been certified as a class yet. It's a separate case. We need discovery. There needs evidence to prove damages if there is any. For that case, though, they changed their contracts, and those changed contracts have to be entered into the regressions and the discovery for that case. And those changed contracts were a direct result of your lawsuit. And yet, I guess when, for years this case was dragging on and people say it wasn't doing anything, it was a waste of time. And how frustrating was it when you were seeing at least some results coming from it? Maybe not the massive results you're hoping for, but some results.
Oh, it's always been very frustrating to us. And sort of, behind the scenes, I warned our guys, this is going to be a lonely road until we get to the end. And when we get to the end, you're going to end up being thanked. But until then, we're going to be alone. That's basically the experience of all the other sports. There's definitely, it appears to us, a stigma to even acknowledge the changes we've already made. I mean, Francis is a free agent because of the lawsuit Kung filed. That's not a guess. That's a fact. He is. Their people won't even acknowledge that's true. They want to acknowledge we exist. They want to acknowledge we've asked to speak to them dozens of times, dozens. Never spoken to them at all, which we find odd. Francis is coming up. He's going to earn probably more in one fight than he ever earned in his career, thanks to us. We have many other ideas as to what Francis can be doing, what other fighters can be doing to get Francis opponents so they can get similar type paydays. Our barrier is we never get in the room to pitch. The managers keep us distanced for whatever reason. The fighters don't know about us, which to us is very, very bizarre. It seems to me if they were, doing their diligence, wouldn't you ask the people who have actually accomplished change? Wouldn't you ask them, what else are you working on? What ideas do you have going forward? We don't even get asked.
That's a good. Do you think the barriers that, I mean, because I talked to a lot of fighters, and there is, amongst veteran fighters, there's awareness of the case, especially now that there's potential for damage, because they all are waiting to see if they can get some damages, right? Even fighters that are way outside the class period are interested because I guess they can't come to the terms with the fact that they're outside the class, that they will not be getting damages. But is the barrier mostly, you think, like the management is talking fighters out, or managers whose job it is to represent the fighters' fiduciary responsibility, be fiduciaries for the fighters, that they're the ones that should be reaching out to you to hear what you could do, what your ideas are that could enhance fighters' income?
I've said many times, our biggest impediment is not Dana, it's the managers. The managers want to keep us, for whatever reason, away. There's a big fear about being affiliated with us. So much so that there's even been occasions when, I'm trying to do educational meetings with groups at a time. So not one-offs, but I want to meet with 30 people at once. I have trouble getting into the gyms because it's me. I have to find a neutral location somewhere. At times it's been hotel conference rooms because I can't do it in the gym. They don't want me there. That's happened sort of repeatedly as well. I hope that's going to change as they start seeing more concrete changes. And again, there's only one group making these changes. It's nobody else. It's no managers that are doing this. It's us. It's just us.
Is it possible, I guess, for the management side, do you think it's more likely it's because they're so terrified of the power the UFC has, the influence purses, and then they can come back and be retributive on them, come up for retribution if they deal with you? Or do you think it's the argument that a lot have been made that a lot of managers are brokers and their interests lie with the UFC and not the fighters? Or do you
I think it depends where they are. So there's using Francis again. Francis isn't even in the UFC. So what's the fear now? That is bizarre to us. It's like you are now in a position where you can actually wield a weapon on your own, Francis. There's levers you can play now that will be not only good for you, but the entire industry. And we're not asked. I find that very, very bizarre.
So there are, besides the antitrust, because your goal in the antitrust lawsuit, and we'll get to, I guess your goal for the future is the antitrust lawsuit is one, damages, but also injunctive relief to limit contracts. You want to propose your group, the MMAFA, and I should have cited that. You are also the attorney with the founder of the MMAFA, which is an association for fighters. One of your goals is to get the Muhammad Ali Boxing Reform Act passed expanded to cover MMA, so that, and I guess the argument you guys make is that would prevent the promoters from owning the titles. There's some debate about that, if it interpreted that way, but that's your goal. But do you have other ideas in your mind, other methods that you think you could weaken UFC contracts or MMA, other promotions contracts, and set up a more competitive landscape for fighters?
Yes. In fact, I think I have a roadmap that, if followed, will lead to either a concession and outright release, or the threat of a judgment that undoes the UFC's contracts with star fighters. One of the two. Either way, that's going to benefit Francis. Why haven't they asked? I mean, I basically, if you follow the MMAFA's Twitter, I tease it. I tease these ideas repeatedly, over and over and over and over again. Nothing.
And no one contacts you. Okay. But what about other promotions? Do other promotions ever contact you about, and I know the answer to that because I know, because the other promotions in this, doesn't it seem likely that the other promotions in MMA, there's kind of like two types of promotion. One loves the status quo because they serve as a feeder to the UFC. So they don't want new entrants into it because it potentially pushes them out of being a prime feeder to the UFC, which is their goal. And the other is if you look at the ones that are getting all the venture capital, their pitch is basically, we're going to be the Pepsi to the UFC's Coca-Cola. They don't want the system to change because they want to build a parallel universe, basically a parallel, like the WWF, WWE, and the WCW in the back in the day, a parallel universe where they can operate just like the UFC and not actually compete.
100%. John Fitch just gave an interview the other day, the one with Jimmy Smith, where he's talking about the regional shows like the status quo. They love it. It's just them. Nobody else can come in because they are already the feeders to the UFC. They don't want any other ones to come in. They don't want, somebody to be able to raise a fighter from amateurs, grow a local fan base, and be able to do their own shows in the Bay Area or, Cincinnati or Chicago. That they don't want that. And then you get to sort of the tier up promotion, which is really only Bellator and PFL. And it's patently obvious to me, they don't intend to compete. They don't want to compete. They don't want the Ali Expansion Act to come into existence. They want, as you say, to be able to go out to, I'll call it stupid money, selling them on the idea we're going to be Pepsi to UFC's Coke. Now, if you ask me, in my opinion, they're setting money on fire. They're stealing it from stupid people who are investing in a product that will never work, because the investors don't understand the sport. People who are raising money, I'm pretty sure, do understand the sport, but they're getting paid all along. So they don't give a shit what happens 5 years, 10 years down the road when that promotion inevitably goes bankrupt. They don't care. If just as another aside, if you followed Bellator's filings the last time we were in DC with the Ali Expansion Act, it was very, very, very apparent they were trying to straddle the fence. And their straddle was, we're trying to appear a pro fighter while at the same time making sure Congress knows we very much oppose this act. That's what they were doing in their public filing. Not many people understood what they were seeing when Bellator did that because they were cute about it, but they were clearly opposed to the Ali Expansion Act.
Yeah. I mean, I remember pointing that out at the time because they had publicly made statements were very much in support of it. I did an interview that Scott Coker did, but then I think Tracy Long, was it their attorney at the time? Tracy Long is a different company right there. Makes it up. But she filed a statement on their behalf saying they supported it, but then they wanted removed all the stuff that made it function as a bill that creates competition. So it was very two-headed on their part, two-faced. Yes. To get back to the lawsuit now that you have class cert, I want to go through this appeal because right now the steps are going to be is that the defendants now have filed their notice to their petition to appeal they to the Ninth Circuit. That's the next court up, the appeals court that makes a decision if this judge made the right decision on this. They filed. Then you guys are going to file your reply to that. And then I guess before the end of the year, we should get a response from the Ninth Circuit if they're going to review the judge's decision, his class certification or not. And if he doesn't, then that's a game changer. If they decide not to look at it, that's massive because that means we've already know you're going into trial early next year. But here's some of their stuff they're appealing. And from my point of view, these are pretty strong arguments. I'd like to hear if you can reply on any of them. One of their things is they claim that the plaintiffs, you have not presented a common method for demonstrating individual antitrust impact. In other words, that the fighters, because there's such a wide variety of fighters, and some of them, are maybe unranked, some of them are ranked, and there's no way to show the individual merit of who would get damages. And even if the UFC was operating in a competitive market, which one of them would even be in the UFC getting paid? So do you know what the response to that is? Do you think that's a strong argument by the plaintiffs or not?
So Nash is pointing out their second basis of appeal. Their first one was actually a criticism of our use of wage share compared to just nominal wage level.
I was saving that for later because I like to talk.
Okay, so I'll skip over that. We'll come back to that one.
Let's go back. Since you're on that track of mine, let's talk about wage share versus wage level. They're talking. I just personally don't find that as strong, so that's why I was leaving. But they're talking about the idea that in this case, because you want to talk about the percentage that should go to the fighters, and they're like, well, that doesn't really matter because in all other cases, we talk about if wages are going up or not, or being suppressed or not.
Correct. So what is meant by what Nash said is the UFC is making the argument over time. Back in 2005, they may have been paying purses of $4,000 and $4,000. And then when you get to the end of our class period, 2017, they're paying $12 and $12. So basically they're saying if we were a monopsony, we wouldn't have to pay a dime more let alone before you even get into percentages, we could have just stuck them at 4 and 4 and kept that level. Why would we raise the wage level if we were exercising monopsonistic control? Now, our response to that is, unlike any other industry, in particular combat sports, the fighter is not an input into an end product. So the example that we use is an iPhone. An iPhone has thousands of engineers who work on various components of this product. And then at the end, when it's sold for $1,200, how do we know what engineer contributed what value to this end product? We don't know. Now, in combat sports, we know almost down to the penny, because the fighter's not an input, they are literally the product. Not only are they the product, we know, unlike virtually any other industry, the exact costs of production and the exact revenues that event generated with that fighter participating. That's why wage level is appropriate in sport, because the athletes are the product, and in particular combat sport, because it's individual and we can narrow down very, very accurately revenues out, revenues in. So we know what their revenue produced is, which is why we say wage share is appropriate. Now, if you look at what was occurring in the UFC over a period of time, basically you see their wage share start to increase 2007, 2008, going into Strikeforce. Why would it increase? Well, because they had competition at that time. Pride existed. Strikeforce was coming on. Some other shows were doing some big shows, Affliction. So their wage level goes up, and then post Strikeforce, you see their wage level go down pretty substantially. And not only does it go down, you start seeing in their internal correspondence and in their communications with their bankers, they intend for that wage level to never get above 20% again. And lo and behold, what happened? From 2017 to 2022, Nash estimated that percentage has decreased from 19.4% down to 13%. Keeps going lower as the UFC's revenue increases. So that's sort of the response to the wage level. Sports is unique in that we have the data and we know exactly what the product is. So you can allocate very, very accurately down to the individual.
Yeah, the wage share one doesn't, because the other thing too is the problem I think some people look at is this is labor in the sense of like people at a factory working, when in many ways they're independent contractors that are independent businesses. So to me, the obvious comparison, even if you use the App Store comparison, the argument is Apple has a monopoly power over app stores because they can charge a ridiculous fee for using their app stores, 30%. And they keep it at 30%. It's not that every year the inflation might increase the price of the apps, but the Apple still takes that 30%. And we're way it's reverse. It's the cellophane policy. They've set a price, they've taken the maximum amount, and they just keep it there every year. And I think that's the argument with the UFC. That's why the wage level, wage share, their argument in the appeal is not convincing me. But the other ones, let's go back now to the common method, because these ones I think are much stronger. These are much stronger arguments.
So your second argument, is essentially the UFC is essentially arguing Dr. Singer can show class-wide impact in terms of damages to the class. What the UFC says is the defect is the UFC says once he's determined class-wide impact, there's no way for him to effectively allocate that class-wide impact down to the individual level. They say he just pulls an assumption out of a hat and does it sort of uniformly. Our response to that is, no, not only does he not just pull it out of a hat, the UFC pretty obviously, and the judge actually cites this, had pay tiers and basically a pay structure that they repeatedly admit we're not deviating from. You see this in sort of the correspondence back and forth when fighters are trying to negotiate deals, and the response is, I'm not deviating that for one fighter. I have to justify that to the other managers. I have a pay structure. I'm not screwing that up. Things like that. And then the other response is, unlike some of the cases they cited, like one case that they cite is NCAA walk-on, with the sort of the idea being, if an NCAA walk-on is now participating in the scholarship pool, they should, in theory, be taking a spot from somebody who had a scholarship before. So you have a substitution problem. Who ends up with a scholarship and who does not out of the pool of people that are on a college football team? Well, in our case, we don't have a random pool of amateurs. The UFC is pulling from what Dr. Singer called the ranked pool of fighters using Fight Matrix, or I believe Fight Matrix is the main database he used. Essentially, the UFC is pulling from already established fighters that are sort of already at the top of the regional level before they get to the UFCs. They're already up levels from the vast majority of fighters. So you don't have that sort of random substitution problem.
It's interesting. Well, I mean, that's been my complaint about your case in weird ways, because I think it's almost to displace the rankings you guys made to me that the Singer's model uses a wide range of rankings as part of the damage class, and it's and for me, it's much more obviously, I use the IBC of New York case. It's the champions, the very top guys that are the source of the damages. If you're going to have monopoly power, you have to control them, and that's the argument. I found interesting, one of the footnotes the judge make is he cites, actually, he talks about the International Boxing of New York, and he also cites the fact that it's the controlling of rank and title that gives UFC power. He has a footnote on that. I don't remember that argument being made by you guys in this case. And so I'm curious your thoughts. It's kind of interesting that the judge brought up something that I agree with, and I think I've seen your presentations to the ABC you agree with, but I don't remember that being brought up by your side in the case. So is this judge better informed than we assume, or?
You'd be watching show money.
Yeah, I mean, obviously for me, not for Jason Cruz or Paul Gift, those guys. Listen, who wants to hear those guys talk?
But I mean, to answer your question more directly, the judge is clearly showing more nuance than what he got from our direct papers. I agree with that. He's picking up on things that all the pieces are there, but he's now putting all the pieces together in a way that I was optimistically surprised by. He's sort of figured out how the UFC is using Ascension to dictate contract term. That is not intuitive to most, but if you read his footnotes, like you said, I think he's doing that.
But one thing though to bring up on the version of the model that I like, and this is a criticism towards the Hal Singer's model, is that it shows no damages for about a dozen, I think 13 or 14 fighters who are basically the biggest fighters in the promotion's history, like Brock Lesnar. And under my interpretation, I have to agree with these critics. I would assume that the most damaged fighters are actually guys like that, because if you use the boxing model, you can just do a comparison. You know, Canelo Alvarez sells this much, Brock Lesnar sells this much. Brock Lesnar should get a similar payday as Canelo Alvarez, but we didn't see that. So what's your take on that? Is that a proper criticism?
It is a criticism, and Hal was asked this during the classification hearings. Hal's model, his regression model that he's establishing class-wide impact and damages in the league case for, showed impact for 1,514 fighters out of 1,528 fighters. So 14 fighters he's not showing impact. And he was asked directly for exactly the reason you stated. It's intuitively illogical for people who know the sport that those guys weren't injured. And Hal's response is, no, I'm not saying they weren't injured. I'm saying under my regression that captures over 99% of the class, they were such outliers, I couldn't capture them in this model. They were off the chart in terms of the regression, that he couldn't reliably say this regression impacts them one way or the other. They were just such outliers. Now, he during that hearing, he's asked, are you saying then that these guys are not damaged? And Hal says, no, not at all. In fact, they were probably damaged on the high end. This regression doesn't capture them. There could be others. He says that. Just not in this model. This model did not work for them. But I agree with you. I don't believe that means they were not damaged. In fact, I would say they're probably damaged on the high side.
Well, I guess the one positive, if you're worried about the little guy, the Hal's regression model shows the damages are for the little guy more than for the guys that made a lot of money. So if there's damage awarded, the little guy will at least will get the lion's share of the rewards for that. And we should to go on really quick, and then some of the other complaints about the appeal really quick. They also argue that you guys cannot distinguish between the impact of pro-competitive and anti-competitive conduct. In other words, you can't show that that you say there's two different things happening. You can't show how much of the damages is because it's anti-competitive and how much of these damages are from the fact that the UFC is so good at their job. Basically, the pro-competitive stuff that the UFC brought in all these fighters, and because people are so interested in seeing all these fighters together that it increased their revenue and value, that you cannot distinguish the difference between the two of them.
I think my answer on this is going to be brief. I'll say the judge heard those arguments, and essentially what those arguments boiled down to was the UFC saying, just because we're such better promoters and we have promoter acumen and we have this special sauce on the side, our events are so much better. The judge basically shows, in my opinion, disdain for that theory. He basically says there's nothing in the record that supports that whatsoever. And in fact, their economists, while making that argument, offered zero support for the suggestion it's some sort of special sauce. What the judge said there is ample evidence for is the UFC using brutal coercive tactics to lock up fighters for the vast majority of their effective careers. That's what he said. That's why they're in their position, not special sauce, not promoter acumen, not because they're better at what they do, because they have basically 1 through 15 in every weight division. And now, in order to compete to get to the top, you have to sign with them.
The final argument they make is that there's another case now in front of the Ninth Circuit. I believe it's in front of the Ninth Circuit, the Google Play Store case appeal, where Hal Sanger is also the econometrician on that, and put a model that they're arguing is wrong, and they're claiming that his model in the Good Play Store, the Google Play Store case, is flawed. That like each individual developer would pass along their cost savings from if there was lower development fees from Google's to the consumer. And their argument is that this is like similar to your model, that the UFC that because if the UFC didn't have this market power, those savings, that money would flow to the fighters. And they're arguing that's a false assumption because there's not a commonality that he assumes there is. I think that's my attempt to explain it to the layman. I might be wrong there. Do you have any points to make about that argument about Hal Sanger's models, or?
What Nash is talking about is their third basis of appeal basically pointed out to the Ninth Circuit, hey, you guys are hearing the appeal in the Google Play Store, and I believe it's like September 12th is the oral argument in that case. At the very least, Ninth Circuit, put our appeal on hold until you figure out what you're doing with that Google Play Store case, because you may want to remand us back down to the trial court level with questions based upon your decision in Google Play. Or you may think your decision in Google Play is somewhat more dispositive on the merits of their appeal. At least wait until you figure out what happens with Google Play before you reject our notice of appeal or our petition for appeal. That's basically their last shot at getting the Ninth Circuit to accept the basis of their appeal. They're saying there's another relevant case that you are now at oral argument stage. At least wait, see what happens with that case before you decide on ours. Now, my understanding, if they're at oral argument stage September 12th, they could be to the point where they're going to get a written decision, say in the next 4 to 6 months after that oral argument. Just in terms of timing, when I researched this about a year ago, whole process is about a year to 2 months, 3 months, maybe 15 months total, from the filing of the petition to appeal to the briefing schedule to oral argument to written decision. That process seems to be about 15 months long. So if they are now at oral, you can figure they should be at written maybe in the next four months or so.
That should be right around the time that we might get a decision on whether or not they're going to accept the appeal at that time, 4 months, at the end of the year.
Yes, and what Zuffa is basically requesting is don't make any decision on ours until you see the result of theirs.
So basically delay it a little longer.
Yes.
Yeah.
So it's another delay tactic. Yes.
Well, and it seems smarter than the longer it delays, it's a win for UFC Zuffa, because your damages, don't increase with inflation. Your damages are frozen. So as their revenues and profits enlarge, your damages actually shrink for them. And plus there's the pain and suffering and cost on your end that you guys have to recoup at some point.
Now to John's point on that aspect, that's true on Lee. Lee's case was December 16, 2010 through June 30th, 2017. And that's on the early end, the December 16, 2010 date is just statutory. It dates back four years from the date we filed. And that's to basically discourage private plaintiffs from knowing about a suit and sitting on it for 10 years, 15 years, and then coming, oh, voila, trying to get 20 years of damages. They're trying to encourage and basically mandate that plaintiffs, when you first know that you have a case, you better start working on it, because you're going to be told you only get to look back 4 years. Now, on the late side, June 30th, 2017, Lee's case stops there, not because it had to. It stops there because we didn't get any more economic data from Zuffa beyond that date. So when we turn over the data to Dr. Singer to model damages, he doesn't have anything beyond that. So what he did is he defined the class. It ended June 30, 2017. Now our fix for that, because we have a time period gap, our fix for that was we filed the Johnson and Dalloway case. We filed that in June of 2021. I believe it was like June 21st, 2021. Looks back 4 years. So it goes back to June 30th, 2017. So we don't have a time period gap, and it goes to the present. Now, what the judge did at the subsequent hearing, he certified class August 9th, and then we had a status conference August 21st. At the August 21st hearing, the judge walked out, and within minutes, he made it very obvious to both sides. Lee's going to be fast-tracked due to the passage of time and the import of the case. It's going to be fast-tracked for trial. I'm going to schedule that for March or April of next year. Following that, we're going to have a damages trial in Johnson. I'm going to lift discovery in Johnson immediately, meaning we haven't even started discovery in the Johnson case yet. What lifting the discovery stay means is now we're going to get Zuffa's next round of financials. We're going to get their next round of promos, their next round of all their internal correspondence with the executives, managers. And we can start serving third-party subpoenas again to build up the Johnson case.
I should point out, too, the judge also ordered the unsealing of documents for the Lee case. It was implied to me, and I don't know if it's correct, that he, going forward in the Johnson case, he might not have as much redacted and sealed. So if we start getting complaints and evidence presented to the court from Johnson, we might get like more information than we did in Lee, the way it came about, that we become less redacted when we get it. Is that accurate?
I think just as a practical reality, I'm not sure that Boulware made that. I'm not sure he made that direct of a ruling, but as a practical matter, I think that's going to be correct, just because of the policy reasons he cites. The passage of time, the import of the case, the delay that we've already sort of endured, and it gets harder to argue this is trade secret type stuff when it's 8 years old or 10 years old or 12 years old. Johnson's even coming up to that now. I mean, his case starts in 2017. So that data is going to be 6, 7, 8 years old by the time we see it. I think the exact rationale of what Boulware has said is going to apply in large part to the next round of documents. Now, what I want people to understand, and Fitch was kind of correcting the record on this in his podcast, that doesn't mean, I believe in our case, if you look on our website, it says 800,000 documents. I'm virtually certain it was over 1.2 million documents when all was said and done. I believe our site just didn't get updated. That doesn't mean all 1.2 million are going to be unsealed. It means anything that we filed in connection with building our case, that's what gets unsealed, with the exception of if it has Kung Lee's phone number or Bill Isaacson's email address and the phone number, things like that. Personally identifiable information will be redacted, or the other exception he made was medical information, redact medical information. Anything else, any of the financials are going to be unsealed. And just I know some of the writers have asked me about this. We had a fourth expert report that I believe was entirely sealed, or for the most part, entirely sealed. That was the Guy Davis report. His report is basically an accounting. It's an accounting of cash in versus cash out. So you'll see one of Zuffa's arguments in the petition of appeal was, if plaintiffs win, they're going to destroy Zuffa as a company because that's basically their damage award. Our revenues are only 5% of that. Well, if you follow their cash in, cash out model, you'll notice the reason their net income is showing low is because they've paid out billions in advance to the owners in which they fund with loans. That's not operating costs. That's not operating expense. That's them taking money from the future to pay prior owners. That's their problem. That's not our problem. That's their problem. Guy Davis actually traced that through 2017. So I believe writers will have an interest in seeing that.
Why do you hate capitalism so much, Paul? I mean, why? It's proper, it's a proper business thing. Anyways, okay. So we got the appeal coming. We'll have a decision at the end of the year from the Ninth Circuit if they're going to accept the review of the case or not. If they don't, we go to trial for Lee in spring of next year. Johnson will start at that time. If they do pick up the appeal, we're looking at probably a year-long appeal process to go to review the briefs and stuff, and then either they overturn the judge, they send it back for questions, or they affirm his decision. So we're at a point where either we're looking at trial next year, or we got to wait till the end of next year to see what the heck's going to happen to the case.
So this was also from that status conference on August 21st. The judge says after he tells us he's fast tracking Lee, he's scheduling Lee for trial March, April of 2024. I'm going to work backwards from that date. So he dated back essentially 90 days from March, and he's like, I'm going to schedule a summary judgment for November. So you guys can file your summary judgments. Plaintiffs, you reply 4 weeks later. We'll have a ruling before we get into deep into 2024. He was making it, at least in my view, the way he was scheduling items made it appear he finds it highly, highly unlikely he's going to rule in their favor on summary judgment. Just as an example, he scheduled the UFC wanted to make some discovery requests. Basically to supplement the record. And basically what their argument is in order to proceed with injunctive relief, the plaintiffs have to show that what they were alleging in terms of barriers to entry still exists. So we want to do discovery to show all these robust competitors that now exist that popped up after the close of our discovery period, to show that what plaintiffs are alleging in terms of barriers to entry is not true. The judge says, okay, I'll let you try that. I'm probably going to deny your request, but I'll let you file. And he schedules that for the exact same day as summary judgment, which is a strong indication he doesn't care what that discovery requests or says. And it sort of appears he's made up his mind that our discovery record, as we argued, was complete through June 30th, 2017. And whatever happens post that date is irrelevant to the Lee case. It goes into Johnson. It seems like the judge is going to do that. So under that scenario, we would brief summary judgment in November. It would probably be decided in January. We'd go to trial end of March or April, unless Zuffa's notice of appeal is taken. If their notice is taken up, I figure we would be scheduled for briefing maybe May or June of 2024, maybe oral argument towards the end of 24, and then some sort of decision probably early 25, which would put us, say, summer to fall trial 25 if the appeal is taken. Obviously, we're hoping there's no need to take the appeal. The Ninth Circuit denies the request, and we go forward with trial.
Well, that's the reason I didn't bring up summary judgment. I thought it was I read the same thing, and I inferred the same thing, that it's a done deal. It definitely sounds like, from especially his wording on everything else in that class cert. It sounds like he's made up his mind. We're going to the summary judgment's a done deal. But if we get, okay, so now the point is we go to trial and stuff, we also have this injunctive relief, but injunctive relief is going to be decided, argued about, and examined during the Johnson case. For the trial for Lee, it's only the damages. And the damages, I've seen a lot of people say this, it's going to be the judge deciding this. No, the damages are going to be determined by a jury. That's correct, right? Jury determines the damages.
Yes.
The judge is the one who makes up his decision on the injunctive relief.
That's correct. And my understanding from what Boulware said is he's going to go damages Lee and then damages Johnson. And then post damages Johnson, he's going to have an injunctive relief hearing.
Okay. So
he's going to do discovery simultaneous with Johnson for injunctive relief, but the actual hearing is going to come post liability Johnson.
So for the discovery for Johnson, is they're going to look at the current landscape of the MMA market of how competitors are doing, and this is both for the damages and injunctive relief for them. They're going to look at the competitive market, what the market looks like now, what the contract situation is, and then because the Zupa's argument, the defendant's argument, is that the landscape has changed completely. And so the whole argument is like, well, let's look at this new landscape to determine if there is a case, if there's really is damages to the plaintiffs, if they have a case, if they have a class, and what injunctive relief should look like. So I guess one thing is Zupa changed their contracts again recently. Is there a class in Johnson because there's an antitrust waiver and a class action waiver and an arbitration clause in their new contracts? I think they're universal too. Apparently, they introduced that in 2019 too. So I'm guessing it must have been for debuting fighters that weren't part of the Lee case, but I could be wrong. But I only learned about it recently because it seems universal in all new contracts. If they're signed to that, they're theoretically taking out of the class action. So do you have any class members, because they all might have signed waivers saying I can't take part in a class action?
So the two named plaintiffs that we filed the Johnson case with, Cajun Johnson and CB Dalloway, their contracts came pre these changes and they didn't fight after. So we're confident we still would have a class going forward. Now, I believe, are going to have to litigate the enforceability of those waivers and those arbitration provisions because they were inserted at a time when there was pending antitrust suits alleging monopsony power. In fact, we not only alleged it, I believe we've established they're exercising monopsony power. And to just jam these completely one-sided clauses into fighters' contracts during a time when there's already the pendency of a lawsuit that addresses exactly these practices seems to us to be grossly unfair. To your point, if they did establish those clauses sort of blanket wide, class wide, starting in 2019, it appears to me our class is going to be small. It's not going to be non-existent because our two named reps don't have those clauses in their deals. But if 85% of the class does, I mean, obviously that impacts the feasibility of such a suit. And I believe we're going to have to litigate the enforceability of those clauses.
Now, and for injunctive relief, what you guys are seeking is you're seeking the judge to make changes to the UFC contracts to make the market, I guess, more competitive. And it would just be the UFC. Is it fair to say that it was in previous complaints and filings at the hearing? I believe Kramer, I read some quotes of Kramer had argued what you guys are seeking. And I've seen your presentation at the ABC and other interviews. I'm guessing the option what you guys are seeking is one of two things. You guys either want contracts only to be a year, maybe 2 years max with no tolling provisions. In other words, no champion clause, no injury clauses, extensions, no extensions whatsoever, 1 to 2 years max, then you're automatically a free agent, or no exclusive contracts. I've seen you bring up that from the IBC case, International Boxing Club of New York case, which was the ruling the judge, the relief that the judge ordered in that one. Is it fair to say that's what you guys are seeking, something along those lines?
I think that's exactly what we're going to be seeking. Almost assuredly, it's going to be along one of those two lines. And sort of what we have to do in injunctive relief is we have to create a scenario where free agency is drastically increased so that fighters can figure out what it is they could actually earn. when they're never free agents. They don't know what they could make, and there's also a giant fear that they have to overcome. Going back to Francis, in our scenario, we would go to John Jones if they ever asked us, which they haven't, but they should. We would go to John Jones and we would say, "Hey, John, you're going to be a free agent in a year. Don't sign I don't care what the UFC gives you. Don't sign that, because your next fight is going to be Francis Ngannou. And if other idiots can't figure it out, we will. We'll put you in Cowboy Stadium. We'll partner with Showtime and Stephen F. Spinoza. You guys will make $40 to $45 million a piece. We'll sell the rights worldwide. You'll make more in one fight than you have during your entire career." Now, the fear that fighters have now is sort of what happened to Francis. Francis becomes a free agent. He's going to earn a giant payday, but not as an MMA fighter. He's got to box. After he boxes the current world champion, by the way, which is bizarre, since this will be his first boxing match, slightly unfair in my view. After that match, who's his MMA fight? I don't know. I mean, what big fight does he have to sell the public?
In many ways, you could make an argument this it demonstrates the restrictive nature of the business, because he is a fighter that the PFL seems intent on offering a large amount of money compared to most fighters' current contracts, and yet no fighter seems capable of accepting that offer. That's a high enough caliber fighter to make it worthwhile.
Right, which is why nobody else is able to put on pay-per-views. They don't have access to the pool of fighters that can sell pay-per-views, and it's just as simple as that. Yeah, Francis can't fight himself, right? He needs a credible B-side that the public knows, and the UFC has done very, very well to make sure there is no B-side. This is their intent. Now, the other thing that we may seek in the injunctive relief portion is stuff like you took video game rights in perpetuity. No, give that back. Those rights expire to games made. Some of the identity rights, give them back. That's something we may seek as well in the injunctive relief portion, particularly since we couldn't certify the identity class, but that doesn't mean that we believe, or even Dr. Singer believes, they weren't damaged, or even the judge. I think the judge wouldn't say he doesn't think they weren't damaged. We couldn't establish on a class-wide basis because the claims are so individualized on the identity rights side. We couldn't adequately model them. So we could seek to address some of the more egregious practices in the injunctive relief portion.
That's right. Okay, so now I should point something interesting too. I should point out is that you represent the MMAFA. Now the antitrust lawsuit's different, separate, but there's a lot of overlap between the membership of the plaintiffs and the MMAFA, right? So I guess the MMAFA, it's been around 15 years now. I'm trying to remember the date you started that, but it was.
I started doing, I started making calls and sending packets. In fact, you can see if you watch. I believe it was
the Sean Shirk fight. I remember you had him like 2007. He was wearing shorts or something. Yeah,
Sean Shirk versus Nick Diaz. He has MMAFA on his shorts. So that would have been a month or two after I had, sort of actively started talking to people. In reality, I didn't get any traction until Elite XC, which is about 2008 or so.
And it's been around since
then. Yeah.
Okay. And then I remember you guys did presentations and stuff around UFC 100. You were talking to fighters and stuff and doing presentations. But but you have this now. You've been around 15 years now, basically, and there hasn't been a lot of traction. There's not been a flood of fighters joining the MMAFA. In fact, I talked to a lot of fighters, and a lot of them are genuinely. They're unaware of the MMAFA. They're also unaware of the lawsuit, which is kind of sad. Some of them, I said, the newer guys, the older guys are aware of the lawsuit. And I should point, it's not just you, that every attempt to do something to organize fighters, those other attempts to unionize fighters, be it I can't remember all the different names, Project Spirit and the MMA AAAA, all those groups basically crashed and burned, that they can gain no traction, which is interesting because The Athletic did a poll and it shows there's overwhelming support by fighters to have some sort of representation, be it a union or association. Is it frustrating to you? Is there a reason why that even though fighters express immense interest in it, that there seems to be little interest from the fighters?
That is frustrating. I would say another great source of frustration is that there's a reason we're the only ones left. We're the only ones working on the solution. All these other efforts are spinning nonsense and seeking press. And I honestly believe that. If they understood this industry, they would know fighters cannot be employees. Can't. It's not an option, let's make them employees so we can bargain. No. They cannot be employees. And if they can't be employees, that takes out union. Second, if they understood how unions worked in league sports, they would know it's not the union that provides wage growth, it's free agency. Where is free agency in League UFC? There's only one owner. There isn't any. That's another very, very common misperception. The fix that we have to do is we have to make MMA just like every other sport where all parties have to compete against each other. And the way you do that is you have to separate rank and title from the promoter. That is a recipe, and it never should have been allowed for UFC monopoly. It's right in the congressional history of the Ali Act. If you allow promoters to control rank and title or to require long-term exclusivity to fight for their belt, you get just one. You end up with monopoly. The UFC knew this. This was their plan right from the jump. I am convinced of that. It took them until Strikeforce's purchase to finalize their control, but it was the intent all along. Once we get 1 through 15 in every weight category, it's self-perpetuating. You have to sign with them in order to move to the top, and you have to move to the top to make any money because the public doesn't buy guy ranked 28 to fight guy ranked 72. They're not selling pay-per-view events. They're not selling multi-million-dollar gates. We need to see 1 versus 2. And there's only one place to do that, just one, the UFC.
That sounds like a very familiar argument. I know someone else has been making that argument for well over a decade now. I wonder who else could possibly be doing that. Well, I have to say, I do agree with you on that part. I do strongly agree with you because that's been my argument for a long time. And a lot of people do not. I don't think they quite understand how that works. And that if you go through the congressional hearings and stuff, all the different boxing hearings, they kind of lay out that this is how it works. I don't know if that was the intention for the Fertittas from the beginning, but my writing partner, Jacob Devitt, seems to think so. He's looked into it, and I think he agrees with you on that was their intent. Now, I'm not going to go really quick now because I don't want to keep you here forever, but since MMAFA, what your goal now is you have you're moving ahead and you want to win this case, but what is your other objectives? What do you plan for the future for the MMAFA?
We've got to pass the Ali Expansion Act. And this is, I guess, one of the other points of frustration for us. Is people like to pretend we failed. We've had 2 congressional hearings. We were within presidential interference of going to a floor vote and passing that act in 2017. And again, that's not conjecture. We were told by the Energy and Commerce Committee, you are going to a floor vote next week. Round up your guys. I was being told you're flying them in next week. Well, what happened? 2 days later, literally 2 days later, Dana White is tweeting out pictures with Donald Trump sitting in the Oval Office with a UFC belt. We never got to a floor vote. It's called hold up in committee. And what that means is somebody called the Energy and Commerce Committee chair, who was Greg Walden at the time out of Oregon, and said, don't let this come out of committee. You're not putting it up for a vote at all. Even though we already had, as sponsors, the vast majority of the Energy and Commerce Committee saying we agree this should be passed. They had signed on as sponsors. We never got to a vote. That's how close we were. Eventually, they're not they're not going to be able to block us. We will eventually get to a floor vote. But what that bill does is now the promoter has to disclose to the fighter, just like occurs in boxing, what their events generate in terms of revenue. So the next time I'm in front of that promoter negotiating, I know the dollars my events bring in. So I should have, some better basis to negotiate a higher purse. And the reason it really works is it creates a structural remedy that's self-enforcing. And by that, it prohibits promoters from putting up rank and title. No boxing promoter does that.
Well, I should point out there is some debate. Does it actually? People assume it does because everybody's reaction to it, based on the hearings and stuff, is they assume that the promoter could not have their own title. But there is some debate over could you win? You'd have to win that in case. You'd have to win a case on that. But
so if you look at the Senate history, and just to Nash's point, the Senate history says if Wimbledon early on said, hey, tennis players, if you want to compete with Wimbledon, you have to sign long-term exclusive deals with just us. What happens to tennis? You would have Wimbledon UK, Wimbledon Australia, Wimbledon US, and all the other tournaments would go away because they're foreclosed from getting any of the top players, all of whom are going to play for Wimbledon. The comment of that was the restraint of trade that imposes would be obvious to all. That's exactly what is going on in MMA, and it has been for years. For some reason, it's just not obvious.
Yeah, it's not. So you're speaking to a brick wall on that subject because most people don't seem to care. Does it bother you actually? Because one reason I had Matt Stoller on, and he said the way to get it, and he's a big supporter of the Ali Act, is for MMA. Is you need to demonstrate that it's actually desired by the athletes and lesser extent the fans, but mostly the athletes. But we haven't seen, in fact, you will see a lot of maybe behind the scenes they support it, but a lot publicly, there's more public animosity and resistance to the Ali Act being passed, especially amongst the fans, but even amongst the fighters publicly. Publicly, they are against the idea of the Ali Act. They like the idea of the promoters having their own titles.
So we won't know for sure until we actually have a scheduled date to be on the floor. But I am confident that the next time we are scheduled to appear in Congress, that's going to change. We're going to have some big name guys with us this next time. I'm fairly convinced of that. And by big names, like think title holder type fighters, I think are going to come out this time.
Former fighters or current? Because it's
sure.
Okay, because that's the surprise. I mean, we had talked to Nate Corey before, and that's one thing he understood fully. It's very hard for current fighters to come out, and he was looking more to retired fighters and former fighters, UFC fighters, to get support from, because he just understands that there's a massive risk to putting your neck out there for current fighters.
Well, I think we're coming up on a confluence of events that are creating some momentum for us, in that you had this sort of large disclosure of information that people suspected for years, but now we're proving true. And that's through the antitrust suit. You have class certification and this huge sort of damage model that's being talked about. And then the third would be, if we actually get reintroduced in Congress and we're heading to the floor, I think that there's some champions that we've been sort of chirping at enough who have sort of figured out, if I can walk with my belt to bidders, I'll make multiples. I think some of the champions have figured that out, and I expect they're going to come with us.
Last thing I'm bringing up too is you were at the ABC recently, and you talked about how you think the sanctioning organizations are actually setting themselves up to be at risk because they're sanctioning what you consider illegitimate fights, non-sport, and claiming it's sport, that these title fights are not real title fights, because as we know, the UFC owns their titles. They even say they're not real sanctioning organization. These are basically trophies, fight of the nights, or whatever they call them. Sometimes it's different every time, but that they're putting themselves at risk for that. And is this something in the future you guys are looking at, or is this I guess I should say, what is the reasoning behind making this argument?
I think the athletic commissions should be aware in the vast majority of their jurisdictions, mutual consent to fight, meaning you and I can't agree. We're going to go out to the parking lot, put up a ring, sell tickets, and just have a fight. That is illegal in the vast majority of jurisdictions. It has to be considered sport. And the problem for these athletic commissions that have allowed the UFC to do what they're doing is the UFC does not use any objective criteria to reach title status. There isn't any. It's whatever they say. They're the ones that dictate who ascends and who doesn't, who gets a title shot and who doesn't. And in fact, the UFC is going to Congress and telling Congress this. Their own executives walk into Senator Mullins' office and say, our titles are not real. They're ceremonial. If you read their promotional agreements say our titles are not real. Fighters have no property right in holding title. It's at our whim. They're the ones that get to decide who their champions are at any time. That is literally not sport. It's not sport. Yet it's being sanctioned and sold to the public as world title fights. I believe they are exposing themselves to liability.
Okay, so what you're kind of saying is, like, in boxing, we see, like, there's a huge complaints all the time that the sanctioning organizations submit people that aren't deserving of title shots, that don't deserve to be mandatories. But there's the argument that they're supposed to be following a objective rating system, and it's a form of corruption when they bribe people to who don't deserve the title shot. But your argument right now, kind of as an MMA, is that they don't even have the pretense of saying it's objective, and they don't need to do the bribes since they own it. They just can randomly pick someone and then claim that this is a world championship. Is this kind of what you're arguing?
Yes. And the punchline to that ABC presentation was, as bad as Don King was, and he was accused of theft, he was accused of bribery, he was accused of all extortion, corruption, all kinds of things, sued many times, largely believed to steal from fighters repeatedly. And many believe the Ali Act came into being to address Don King's option practice in the 80s and with his heavyweight champions. UFC doesn't even have to corrupt any third party. The corruption is already built in because there is no objective criteria. They're the ones to decide themselves. They don't have to corrupt anybody else. As bad as Don King was, he pays multiples of what the UFC does now. So I'd rather have the crook Don King than the current UFC.
All I gotta say is, you're stealing my material right now. That was you're stealing my material. Me and Fred Garvin on Twitter years ago brought up that comparison and talked about Holmes. So I guess I should be flattered that my material is being repeated that way. So, but okay, well that's I guess the final thing is I guess we're waiting for go back to this lawsuit really quick. I guess going in the future, if you guys, this will be the last question I'll ask you. If you win, if the UFC goes to trial, and I think if it goes to trial, they will be calling you to settle, because the potential outcome in the future is that the UFC could pay billions of dollars. They could lose on damages, and then you'd treble it, so it'd be billions and billions of dollars in damages, and their contracts could be completely rewritten. That would be, for all practical purposes, the end of the UFC as a $12 billion valuation company. It'd be a $12 million valuation company, because there would be, they would basically lose everything that makes them such a valuable property. Is that the risk for them? I mean, I guess for your point of view, I guess you don't care that they face that risk because they brought it on themselves, but.
We don't care at all. In fact, we strongly don't believe the UFC is going away. Their brand is too big. It's sort of too well known. But to your point, what could happen is, instead of being worth $12 billion, it could be worth $200 million, which is what it should be worth. That's what a large boxing promoter is worth. They are worth $12 billion because they've monopolized the sport and get the vast majority of the revenue. If we undo their mechanism for getting 95% of the dollars, of course, their valuation should fall. But they still have a very powerful brand that the public will still have some attachment to. They will still be able to sign fighters. It's just the split's going to reverse. If you want to retain Ngannou, pay him what he would get as a boxer. You'll still be able to sign him. You'll still make some money. you just won't make 80% of the money anymore.
Is it frustrating you at all that if they have to pay damages, the guys that you kind of blame for putting this together, the Fertittas and then I guess Endeavor, that they're not going to be paying the damages? The damages are likely going to come from the pockets of shareholders that are going to be buying the company when it goes public.
Or as we joke, it's going to be Canadian pensioners.
Yeah, unfortunately, because they put a lot of money into Endeavor and stuff. So, or they bought bonds in the FCA.
To your point, does that bother? I know it bothers some of us. Yes, yeah, that's just sort of the unfortunate nature of litigation. And these guys sold at a good time.
On that note, we should probably end it. We've had you here long enough, and I'm sure we've lost every listener on how long this has been. So I appreciate you coming on.
Hey, thanks for having me. I'll talk to you guys.
All right, so there we have it. Rob, do me a favor, if you would. Tell us where to find the MMAFA, where to find you, social media, anything that you want out there. If you want your email, your phone number, this is your time.
Also, we should always point out where fighters and stuff who have maybe questions about the lawsuit should, because I don't want the questions. Don't DM me anymore.
Yeah, so I'll leave with that. So any fighters watching this that are curious about the lawsuit, we are asking you to go to ufcclassaction.com, submit your contact information. You'll see boxes that say contact us. That's confidential. You can request a call, at least make sure we have your contact information. On that site, you can see almost all of the important filings are posted in PDF format. You can download them and read them if you're curious. And then MMAFA, you can find at mmaafa.tv.
All right. Thank you so much for joining us. Folks, please do us a favor. Subscribe to our Substack. If you're already a subscriber, please share this far and wide. On that note, we're going to wrap it up. Until next time, please stay safe.
It's not in the face! Thank you.